So I want to discuss here how to best make yourself valuable as a young lawyer. As everyone knows who's in the profession, you leave law school and the skill set you have is minimal at best. You have a basic understanding of contract law, tort law, constitutional law, which we've now learned with the new Supreme Court justices. If you graduated law school 20 years ago, everything you learned doesn't exist anymore. We learn criminal law, trial advocacy, evidence. But here's the thing, until you actually work, in a law firm, in a government office, you don't really know what to do or how to practice law. So what I do, or what I've done for the last 22 years of my life, is civil litigation. Besides civil litigation, I have done some criminal stuff. I've done some bankruptcy. I've done some wills and estates, some real estate transactions. So I've done that, but mainly, I come and I speak from a very heavy civil litigation front. One of the things when I finished law school that I made sure I did was I got a job. And let me tell you, when I finished law school 20 plus years ago, it was very difficult to find a job. It was right after 9/11. We were in one of our consistent recessions that seemed to hit in the 2000s. So I ended up, of all things, starting in a no fault law firm and then a subrogation firm and then back to no fault. But what I did was I took every opportunity I could to try these bench trials. I mean, I was blessed in a way that I worked at these law firms where we had a very, very heavy small claims docket. We were covering small claims for a bunch of insurance companies, night court. And I would do one, two trials a week. Uh, we had, lower end subrogation cases. I would try those cases. And then back in the day, these no fault cases, we just tried so many of them. Uh, and you start and I mean, you know the rules of evidence, but you don't know the rules of evidence. You know how to object, but you don't know how to object. I guarantee you've never actually crossed a recalcitrant, nasty doctor. You've never crossed a police officer who thinks he or she is always right, or somebody who, says they're not at fault for the accident, even though they rear-ended you. And they swear up and down, left and right, that your client hit the brake and that they were a fair distance behind your client and they don't know how the accident happened, except, your client just slammed on the brake for no reason. These are experiences you're not going to get at law school. You're just not going to get it. And until you actually get into a courtroom and actually try these cases, you're at a disadvantage. You just really are. Uh, Even if you do a lot of depositions, until you actually get the opportunity to, whether it's a small claims case, functional small claims case, you know, bench trial, jury trial, until you actually do these trials and actually put yourself out there, your skill set as a litigator is really minimal at best. The other thing I always did is I always kept up on, the new cases that come out. So I mainly practice in New York and Florida and a little bit in New Jersey. And those three states have websites where every day they shoot out new appellate cases. New York is rich with a whole bunch of trial court cases. I glimpse those. I don't really give much credence to a lot of what comes out of the trial courts, but I'm always reading what the appellate courts have to say because that really is, guidepost of our practice. Filling in the blanks of when you go to court and a judge rules against you, jury rules against you, you lost on a summary judgment motion. A lot of times you gotta look at the cases, look at the new cases that come out, and ask yourself, did I miss something? Is there new developing angle of a long stated proposition. And I'll give you a great example, right? So one of the things we do in civil litigation, besides trying cases, is writing motions. It's a huge part of the practice. A good litigator essentially will write motions, defend motions, more often than not. Uh, something, just to give you a great example, this thing called threshold, right? So we do a lot of personal injury cases, and there's a thing in New York called the threshold. Not to bore you with the details, but either party, usually defendant, could move for summary judgment to dismiss your case, saying that you, as the plaintiff, did not sustain a serious injury. And a serious injury, generally in New York, is three categories. It's you didn't work. Really, it's you didn't work for 90 days. I mean, the statute says you didn't perform your normal everyday customary routine activities of any 90 of the first 180 days. But if you read any of the case law and you practice in this field, it's you didn't go to work for 90 days, right? So you got that one. There's a one called a permanent consequential limitation. And there's significant limitation. Essentially, what that is, those are your soft tissue injuries, right? Neck strain, back strain, knee strain, shoulder surgery, knee surgery. And essentially, what that requires is for you to get treatment relatively contemporaneous to the motor vehicle accidents, to essentially have a functional limitation, which in New York usually means diminished range of motion. If not diminished range of motion, then a qualified test, they call it Sperling's, Jaeger, they have all these really funky names, but if one of those qualified tests is positive, right? And then a lot of times, if you can get an MRI scan or a CT scan that, from a structural standpoint, substantiates the functional disability, if you do that and you get your treatment generally for 90 to 180 days and it all lines up, you're generally going to beat a threshold motion, right? So what was happening is the insurance companies knew that in terms of like whether or not someone suffered a permanent consequential or significant limitation, which are generally the two big ones. Most people from an accident don't miss 3 months of work. It happens, but it's relatively it's less than 10%. So what the insurance companies realized was that they couldn't win because issues of fact were being arisen, right? I'm in an accident. I have back issues. My range of motion is diminished. My MRI shows all sorts of bad things. And there you go. I've suffered a significant limitation, or a permanent consequential. Permanent consequential actually requires that at or about the time of that summary judgment motion, which is normally 2, 3 years after the accident, you have a recent examination, and that recent examination will prove permanency. So what the insurance company started doing is they started saying, well, okay, fine, you suffered this, but it's not related to the accident. So what they would do is they would take the MRI scans, because don't forget, every type of soft tissue case always has an MRI, right? No MRI, you generally don't have a case. It's part of the formula, right? So the insurance company hires a doctor, they read the MRI. MRI is all degenerative, nothing's related, you know. Some insurance companies would get an emergency room physician who would look at your emergency records and say, oh, this is not related to a recent, trauma, right? And for a good period of time, these motions were causing a lot of distress for plaintiff attorneys because you would have on one side a radiological review that is an affirmation doctor form. Then on the other side, you would have, if you ever seen a standard MRI report, essentially it just makes blanket statements, L4, L5 herniation, L3, L4 bulge, right? But the reports that exist for the plaintiffs are like real medical treatment reports. They don't actually state on the report, I hereby opine within a reasonable degree of medical certainty that the herniations on this report are related to the accident, right? So a lot of times the plaintiff doesn't have that, and then the plaintiff would try to rely sometimes on a physician affirmation But the physician affirmation, that doctor wouldn't often, look at the actual MRIs themselves. They would again look at the treatment notes and write an affirmation, which is a sworn statement. And the insurance companies were winning a lot of these cases because the court said, well, the insurance company, they said it's not related. They gave a detailed affirmation from their doctor. You didn't actually discuss why their affirmation in detail is wrong. Now, the largest judicial department in New York State, the second department, which covers Brooklyn, Queens, Long Island, Westchester, Rockland, Orange County. They, starting about 4 years ago, began with a line of cases that says that a defendant not only has to say that it's not related, but they have to say that exacerbations, aggravations, that this accident didn't cause any aggravations or exacerbations. So why is that important? Well, let's face it, if you're a radiologist and you're reviewing an MRI film, right? You could look and you could opine and you can say, oh, this film, it has all this black stuff in it, right? And if you've ever read or if you've talked to anyone who's ever read an MRI, it's about the back of the neck, if a film looks totally black, right, where the discs are supposed to be, that's a long-standing injury. And so what a radiologist will do is they'll say, well, looking at the fact that there's no low water content in there, which is what the MRI looks at. Oh, it's obviously long-standing. So the herniation itself obviously predates the injury, and I could opine it's not from traumatic origin, right? But here's the difference. That radiologist can't tell you that glob, right? That glob of herniated disc tissue, right? That annular fissure, which is where the nucleus pulposus, right, or the inner, because they call it the jelly donut material of the herniation, where it comes out of, that radiologist is not going to be able to tell you, and they're not going to swear under oath that broken disc wasn't made worse by the accident because they can't. They can't do that. Uh, and what we've learned from this is that essentially, if your attorney in their called bill of particulars, which is your discovery responses that a plaintiff files in a personal injury case, if your attorney alleges exacerbations and aggravations of prior existent herniations, bulges, conditions in your, body parts, what we've learned is that the insurance company cannot, within a reasonable degree of medical certainty, find or obtain, sufficient medical records to show that the injury is not an exacerbation and not an aggravation. Now, there is a way they can do that, and that would be the person who can't stop getting into accidents and files lawsuits. Because that person would have a long-standing history of accident treatment, settlement, accident treatment, settlement. Now, in that instance, the doctor could actually get all of the MRIs and all of the functional records, hold them together, and say, look, accident number one, this person had 50% motion. Accident two, they had 50% motion. Accident three, they have 60% motion. They actually got better. In an instance like that, you would lose on the exacerbation test because their doctor could show with actual functional evidence, right? The range of motion that the injury, was not exacerbated. But that's just one of like the really interesting things. And I mention that because when you study the law and you just keep up on what's going on, you pick up on stuff like that. So being a lawyer, in my estimation, and I kind of went off on a tangent there, probably something could be its own topic, but being a lawyer, it involves keeping track of the law, going and learning how to try cases, learning how to do depositions, going there, figuring out how to ask questions, how to get answers, how to prepare documents ahead of time that you're going to use to refresh and oftentimes impeach the witness that you're asking questions, knowing how much is too much. Doing a deposition, you learn that after a certain period of time, your witness that you're deposing starts breaking down, and then you can be a little more aggressive, where you could kind of, up the ante of the questions, and you might actually start getting some really interesting answers. But again, being a good lawyer is just, learning these things, a lot of experiential learning. It's a lot of late nights in the beginning, your first many years, staying late, just researching, learning, writing motions. I like writing appellate briefs. Like I've probably written thousands of appellate briefs already in my career, a lot of different states, a lot of different jurisdictions. That's an art form. It is a pure art form. And if you don't do it, you can't get good at it. I didn't actually, in terms of jury trials, this is a little funny story here. I didn't actually pick my first jury until I started my own law firm. So my first jury trial, I think I was already an attorney for 11 years. I mean, now since then I've done dozens of them, but it was an opportunity that just wasn't given to me at my old jobs. And it's an opportunity I wish I was able to encounter and learn on somebody else's dime. But like I said, I've made it a point to take every opportunity that my bosses gave me and to really make the best of it. And with that, I was able to open up my firm, at least have the skill set to really do anything anybody asked of me. Being proficient with Westlaw and Lexis is a huge plus. You need to know how to use those two tools. Uh, a lot of attorneys I know don't have a Lexis account, don't have a Westlaw account, and I question how they really practice law. But that's a that's a question for a different day. I'm not gonna go on that here on this video here. That's important because one of the things you always need to do is you need to be able to answer your own questions. If something happens, you need to be able to find a source of information that can answer your questions. Being independent and being able to figure stuff out on your own is huge. I mean, I gave you the example of trying a case. You're trying a case, something goes wrong. You can't go, hold on, judge, I got to call my boss. Now, I've had attorneys that have done that, and you could hear in the background the judge yelling. You don't want to be that attorney. You want to be the one, especially now where everything's online. You can bring computers to the court. Your cell phones have access to Lexis online, Westlaw Online. I mean, you could obtain all this information on your own in any. That's being a good lawyer, though, being independent, being motivated, self-starter, putting in the hours, learning tools of trade. I think if you do that, you will definitely be on a good path to success.